Hello everyone, this is Tom O'Connor of Advanced Discovery. I'm here at the beautiful campus on a beautiful spring day in Gainesville, Florida, the University of Florida Levin School of Law, and we're here for their 4th annual eDiscovery conference, not contest, conference, although
it might be a bit of both.
It's a contest for some people, and Craig Ball did try to give a test this morning. Two sponsors, as I mentioned. We've got the school itself and our host, Bill Hamilton. But I'm here at the moment with our second host, George Socha of the EDRM, the eDiscovery Reference Model. George, how are you?
I'm doing okay, and you, Tom?
I'm doing great. I'm having conversations with great friends and a lot of great folks in this business. It always reminds me, that I at a conference like this, I miss our old buddy Jim Kane, who would have just been in his element at this, right?
He would have gloried in
and
this.
then Browning Marian, and
yes.
the two of them would have just found like, wow, we're finally getting around to the things we were talking about, and using this technology the way it should be used. How's the conference going from your perspective?
I think the conference is going well. Of course, as one of the people putting it together, I am abundantly aware of how different it is from what I had envisioned in my head coming into it. But that's the nature of every conference out there, and I think it's going well.
But one thing you're doing and doing very well is a live stream.
Yes.
And what are those numbers, attendance live versus attendance online, if you know?
What Bill was telling me this morning is that we had, in terms of registrations, about 150 in person, I think, and about 350 online. In fact, yesterday the official tally, last I checked, was 503. We have a multiplier factor, however, and that is because not all of the online attendees are individuals.
Right.
We know there are folks who are setting up a feed into a conference room, for example, and they have 5, 15, 20 people in there.
That's great, yes,
and
yes.
we encourage and support that. We think that's a great way to make use of the streaming capabilities of this conference.
And I may be wrong here now. I don't know of other conferences that are doing that. Do you?
I know of no other conference that is doing that. This is our 4th year now doing that. And of course, I've been waiting to see who else comes up with a new idea. But as far as I know, we're the only one doing that.
Yeah, I have seen little enthusiasm for most of the other big conferences to employ the technology to teach technology.
Well, I mean, there are a couple of things. As soon as you deviate from a single track, which we have here, to multiple tracks, it becomes very difficult to stream multiple tracks simultaneously to the same audience. At that point, it's much more complicated.
Understood.
And even streaming just one track has its technical challenges. It's running a lot smoother this year, I hope, than it did last year, than it did the year before, than it did the year before that.
Well, there is a screen in the beverage and refreshment tent where we had breakfast and I think lunch is going on. Now, why are we sitting here if there's free food? There's something wrong with this.
Something is very, very wrong with this picture. But the screen we added last year.
Okay.
So that people could come out, get something to eat, something to drink, without entirely missing what was happening on inside, because we realized if we're streaming to the world, we could stream to the courtyard as well.
Yeah,
there's no reason not to.
I've come out several times to get coffee or water, and there have been people watching, so I think it's an effective technique.
Now, another part of that is because we are not just streaming this, we are recording it. And the recordings will continue to be available for some time, so that if you are in a conference room somewhere, you are at your desk, you get pulled away because something else is more important, believe it or not.
That's
in
hard
our
to believe,
conference.
but
You can come back later on and go to that recorded session and watch it, or watch portions of it at your leisure on your time.
Now, the links to that, I assume will be on the University of Florida's the law school website.
Right.
Will they be on the EDRM site as well?
Yes.
Okay, so people can
go
to either and get that. And will you be able to drill down to a specific session, or you can fast forward?
No.
To be developed?
To be developed. The intention. The intention is
Thanks
not
for asking that question, Tom.
No, that's okay. And here's what we did last year. Rather than putting up the entire day, we broke it up by panel.
There you
so
go.
that you can go to a panel, and when you're there, you can fast forward through the
Right.
panel, but it's a 1 hour chunk, not a 6 or a 7 hour chunk.
That would be helpful to me, and especially even if I'm here, but I missed a session because I'm out doing some interviews, it would be good to be able to go back in and just pull up that session.
And it's always good to be able to go back to something anyway. One of the problems with a conference like this, where it's not being streamed and not being recorded, it's ephemeral. No matter how wonderful the content, it's there and then it's gone, and you can't go back again.
Yeah. So, general question, we talked about the conference itself, but we've had some interesting discussions already this morning. Where do you see e-discovery going?
Maybe one day e-discovery will be properly commonplace. I think there have been some important themes throughout the morning. One, of course, is about attorney competence. Attorneys really need to know what to do about electronic discovery, but that's tied with what their objectives are. I myself think that if the focus of your electronic discovery exercise is limited to a review for relevance and maybe privilege, you are missing golden opportunities. And there's been some discussion about that through the morning sessions. You are missing a chance to dig into that data in many different ways, information that we increasingly know is far more reliable than fact witness testimony, or for that matter, expert witness testimony probably, but far more reliable. You can dig into that in many different ways to try to understand what happened and figure out how you are going to present that in an effective way to an audience.
Okay.
It's a resource and a capability that we've never had, when all we could do was talk with people, read paper documents, and look at tangible objects.
Right. So that comes back to an issue that I always talk about, and it's really related to the technical competence, but if the attorneys don't understand this stuff, to use a George Carlin term, if they really still in the back of their minds think it's black box, it's magic, will we get to that point? Don't we have to educate them first?
We can, but unfortunately, we can only do so much education where we push the education to them. They need to want the education. The thing that continues to frustrate me is that, I was 16 years in 2 different law firms, worked on cases from minor slip and fall to multiple billion-dollar cases. And it was certainly my experience working with my colleagues and working with, if you can call it that, opposing counsel, that attorneys by and large are a pretty smart lot. Mm-hmm. And litigators and trial attorneys, pretty quick studies. And they can go from 0 to 60 on a complicated, arcane topic quite quickly. That's if you can't do that, you are not going to be successful, certainly as a trial attorney, but even really as a litigator, drawing that distinction. This is one more topic. There's no inherent reason why these folks cannot understand and gain sufficient mastery of this topic as well. The problem is we slap an E in front of discovery and we get brain freeze. How do we get past that psychological barrier?
It's interesting you should say that, because that brings to mind several years ago, I think it's probably 3 years ago now, Judge John Fasciola from DC gave the keynote at Legal Tech New York, and he made that point. He said, attorneys aren't learning e-discovery because they can't, it's because they're obstinate and they won't.
This is not a new idea on my part.
Right, but I had lost track of that rationale.
And so I think what's going, they're smart enough to know it. They've got all the tools they need, the intellectual tools they need to learn it, but they're not motivated to learn it. And I think the primary reason they're not motivated to learn it is because their mindset when it comes to electronic discovery is, this is about that review for relevance. It's not going to help me in my case. And what they really should be thinking is, here's an opportunity to learn more than I ever could before and do a better job than I ever could before in building up my case and in destroying my opponent's
destroying
case.
the opponent, I'm looking at my notepad here because I wanted to recall Michelle Lieberman, who is one of the local sponsors in her role. She's the county attorney here in a name I won't attempt to butcher again. But she's also on the 8th Judicial Circuit Bar Association. And she talked earlier this morning about the Florida Bar has passed along a rule change to the state Supreme Court to make technical training part of the CLE structure, the mandatory CLE structure. Much as you need to do an hour of ethics every year, you're now going to need to do an hour of technical training every year. So are we moving in that direction? Is that?
It is
baby step?
Laudable effort. However,
you have the same look that Craig Ball had on his face when I asked him this question.
Who is going to?
Yeah.
No matter how well done a CLE program might be, the programs we're putting on here included. At the end of the day, they do little more than help with issue spotting. You're teaching people how to spot issues. You cannot, in a 1 hour period of time, in this type of setting, bring people up to speed, and you certainly don't have any opportunity to evaluate whether they have absorbed anything of what you're talking about.
Right. Right.
So it's going to be, that type of push, I think, unfortunately, is necessary. The type of education she's talking about is an important component. It's necessary, but the two of them are not sufficient.
Okay.
We need more than we have today, and in more forms than we have today. And it's simply not going to be something easy to roll out. It will take a lot of time and a lot of effort, and we're going to get it more wrong than right for a while before we start to get it to really work well.
Okay. Well said. I can see in the background that the luncheon is wrapping up and people are heading back in for the next session, so I want to let you go and monitor the proceedings. Okay. Thanks so much for your time. From my perspective, great conference, great content. Always enjoy being here. Thanks so much.
Thank you, and always enjoy seeing you as well.
Thanks, George. Thank you, folks.